It's always an honor for me to say or participate in the conference in the name of Asma Jahangir, because I believe everybody here believes so, and there are many witnesses here that how Asma started working for the bar associations. We remember in 2010, we persuaded her to contest the election, and next year she persuaded me to contest the election. So, as the luck would have it, we both won. And she stood like a rock, needless to say, and she was such a companion. I have no words to explain. Those were the moments which we spent together. I still cherish, and I will cherish throughout my life. Because she was something larger than the life, I must say. So, Nida, as you said, I would like to highlight certain points with regard to the judgments passed by the courts of this country, High Court and thereafter Honorable Supreme Court of Pakistan, regarding the rape cases. So I would like to start that women in Pakistan fought a long fight for the protection of their rights under the, of course, stewardship of late Asma Jahangir. She fought a long and hard fight for the repealing of anti-women laws, and we all are thankful to her for her great sacrifices and struggle. There was a colonial legacy, of course, contained in section 155(4) of the Evidence Act, which read as, when a man is prosecuted for rape or an attempt to ravish it, it may be shown that the prosecutrix was of generally immoral character. Unfortunately, in 1984, Qanun-e-Shahadat order was promulgated. This mischievous provision was copied as such and numbered as Article 151(4) of Qanun-e-Shahadat order. And on Asma's persuasion, the legislature passed the Criminal Laws Amendment Offences Relating to Rape Act 2016 and deleted Article 151(4) of the Qanun-e-Shahadat order, which effectively prohibits adopting a line of questioning on the character of the victim. This was a great enactment and made it difficult to rope women in false case of adultery through an amendment in section 375 Pakistan Penal Code, which this particular enactment inserted section 376A in the Pakistan Penal Code, which placed a bar on the disclosure of the identity of the victim of rape. This particular provision removed a great barrier and operates as a bulwark against victim blaming. Prior to this, there was very less reporting of the offenses because the victim would unfortunately keep silent in order to avoid blaming. There was no distinction between a normal criminal case and a rape case, but the statutory intervention has rightly placed a clog on the disclosure of identity of victim of rape, etc. During the colonial times and even thereafter, a killing or killings undertaken to vindicate family honor were considered good grounds for mitigation of offenses. In this case, reliance can also be placed upon 1968, that is Criminal Law General, and 1977, page 690. But with the advent of the time, this practice was deprecated by the courts, and a fundamental right of women to enter into wedlock, even without consent of wali, was held valid. That was in Saima Wahid's case, a landmark judgment where Asma, of course, appeared. Asma Jahangir played a great role in that battle. The legislature finally realized this folly, and through the Criminal Law Amendment Offences in the Name or on Pretext of Honor Act 2016, Section 299EE was inserted, and honor killing was defined, inter alia others, as a fasad fil arz, and a proviso was added in Section 302, through which it has been provided that where the principle of fasad fil arz is attracted, in such cases only, Clause A or Clause B shall apply. Another important provision was inserted through this Honor Killing Act was amendment in Section 310 PPC, which prohibited giving female in marriage for badle sulah. This was great evil. Women folk were treated as property of men. Another provision which corrected the course was a second provision, section 310 clause 1, which made compounding in cases of honor killings subject to section 310, which requires that court has to see that acquittal should be done or not, although legal heirs of deceased have compounded. This caveat was provided a good judicial oversight as few years ago. Supreme Court of Pakistan took suo motu notice and reported as 2013 SCMR page 203 of a rape case, and during the pendency of the proceeding, it was told to the Supreme Court that complainant has entered into compromise. And in another case that was titled as Sadaf Aziz's case, Justice Aisha Malik, then she was judge of the High Court, issued a landmark judgment regarding the admissibility and legality of the two-finger test in case of sexual assault. The court ruled that the two-finger test, which involves the insertion, assesses the laxity, is in violation of the dignity of the victim and right to privacy. And furthermore, the court further highlighted in the same judgment the need for sensitivity and respect towards survivors of sexual assault, emphasizing the importance of trauma-informed approaches to investigation and prosecution. It called for the prohibition of two-finger test and directed law enforcement agencies and medical professionals to refrain from conducting or relying in the cases of sexual assault. In addition to that, Supreme Court of India also passed a judgment. So I would like to refer to the 2021 Supreme Court, a judgment by the Honorable Supreme Court. This is by the three-member bench headed by Justice Mansoor Ali Shah. While speaking for the court, upheld the right of dignity for the victim in the rape case. It's a landmark judgment. Through this law has been settled on the subject of the test already mentioned, an affront to the reputation and honor of the rape survival, and violates Article 4(2)(a) of the Constitution, which mandates that no action determined to the body and reputation of person shall be taken except in accordance with law. Similarly, Article 14 of our Constitution mandates that dignity shall be inviolable. Therefore, reporting sexual history of a rape survivor amounts to discrediting her independence, identity, anonymity, autonomy, and free choice, thereby degrading her human worth and offending her right to dignity guaranteed under Article 14 of the Constitution. While analyzing the legislation, the judgment very eloquently holds, and I quote, it appears that the court has been allowing opinion evidence of the medical experts as to the said test to be brought on record in cases of rape in view of provision of Article 151(4) of Qanun-e-Shahadat order, which was Section 155 of Evidence Act, which provide that when a man is prosecuted for a rape or an attempt to ravish, it may be shown that the victim was of generally immoral character to impeach her credibility. This has now become inadmissible in evidence after the omission of Article 151(4) of Qanun-e-Shahadat order. And earlier, a full bench judgment of Federal Shariat Court has also declared the provision of this article to be ultra vires. So these are general rules, general legal issues which a woman came across in our country, across in the rape cases. So as you said, Nidar, and there was a question regarding the child marriage.
It was an observation that, a lot of, there's a judicial, I would call it judicial violence, when there are judgments that come and undermine the protection and the rights enshrined in our constitution and other subordinate legislation, when the principles of justice are not upheld.
Look, Nidar, there is one thing, that is the approach to the courts. you people are regularly practicing on this side, and whenever, we have lot more to do for the awareness.
Absolutely.
And we are, we take it, we use the word that sui juris, not the adult. We use the word that, it's a marriage, and nikah is solemnized with the free consent of the families, and nobody asks the girl that are you, consenting party, and you are not even 18 years of age. You are a minor. So, but still, we have a mechanism. The courts are sitting. We have the provisions in the law. The legislature has done a lot, I must say, regarding to safeguard the interests of the minors vis-a-vis who are getting married without their consent and they're underage. So the awareness is the issue.